It's a great place to start actually, because you can sort of set the whole framework here, because the fundamentals are that as a US citizen, Michael's subject to worldwide taxation no matter where he goes. So he's always faced with a US tax obligation. Whereas Charlotte, who's in this case just a British individual, is only going to be a residence-based taxpayer. So that's the starting point. And I think the key to what we'll see here and what we do is usually focused on the US because of the potential for double taxation.
Often I find that investing into a direct strategy, so into direct equities, fixed income, can be more efficient because then you can be more granular in the tax optimization. It's typically more flexible if they want to move to a different country at some point in the future. But once all of that is established, you don't have to operate in silos. Whilst they might have all these different accounts that you've mentioned, so a brokerage account, ISAs, US pensions, UK pensions, looking at that all together and having a plan and populating the different asset classes across that is probably the most efficient way to look at it.
Today we're discussing the case study of a US-UK private equity professional based in London with his family. I'm joined by two experts, Ed Johnson from W1M and David Foster from EY. Welcome to you both.
Thank you.
Thank you.
So I'm going to set up the scenario in a moment that we're going to discuss, but before that it would be great to hear a little bit about how you work with this client segment, starting with you, Ed.
Yeah, absolutely. Yeah. So my name's Ed Johnson. I'm a wealth planning professional at a business called W1M. W1M is a wealth and investment management company based in London. The team that I work in, the US private wealth team, really focuses on US connected families and US expats. And so really the scenario that we're talking through today of kind of mixed tax status couple is pretty familiar.
Fantastic. Great to have you with us. David.
So I'm David Foster, a partner in the US-UK cross-border team at EY, and that's a group that focuses on US and UK taxation, so tax advisory services, tax compliance services. So there's always a US connection there somewhere. I particularly focus in the trust and estate and inheritance tax area, as well as working with married couples and couples, unfortunately, going through divorce as well.
Just to set up the client scenario. Michael Patterson, 52, is a US citizen and a UK resident working as a private equity managing director, earning £1.25 million annually with $4.2 million of unvested carried interest. His wife Charlotte, 49, is a British citizen who owns an £8 million digital marketing agency. They have 3 children, aged 18, 16 and 13, all holding dual citizenship. The couple hold a £6.5 million Chelsea home, a complex investment portfolio spanning both jurisdictions, a US 401k, UK pensions, and a Delaware family living trust inherited from Michael's parents. Their marriage is under significant strain, meaning this episode explores both optimised planning as a married couple and the implications of a tax-efficient divorce settlement. So, gents, just coming really for the backdrop here. David, just starting with you on US-UK tax filing obligations and the tax position. Michael is a US citizen living in the UK, married to Charlotte, who's British and UK domiciled. What are the US and UK tax filing obligations for this couple?
It's a great place to start actually, because you can sort of set the whole framework here, because the fundamentals are that as a US citizen, Michael's subject to worldwide taxation no matter where he goes. So he's always faced with a US tax obligation. Whereas Charlotte, who's in this case just a British individual, is only going to be a residence-based taxpayer. So that's the starting point. And I think the key to what we'll see here and what we do is usually focused on the US because of the potential for double taxation. And so it's crucial to all the tax and financial planning is, the essence of it is avoiding double taxation, as well as then trying to reduce the global tax burden. So in terms of the filings, so Michael's always going to have an annual US tax filing obligation, so he will have a personal tax return to file. He's resident in the UK, so he's going to have a UK tax filing obligation. He may still have connections back home to a state of the US, so he may also have to file a state tax return, which is separate from his federal tax return. And there's a choice that the couple have actually in the US. They could file jointly. So they could come together and file a joint tax return. That's their decision to make. It's an option. but it brings Charlotte into the US tax net, so they may not want to do that. We would explore that with the couple. But equally, there's the annual self-assessment in the UK to do, so both of them as UK taxpayers will have to file UK tax returns. But we'd also look at the history that Michael has, because he's not a British person, so he may have previously untaxed offshore income and so on that hasn't yet been remitted to the UK, so that will be explored as well. Whereas Charlotte is going to have a regular UK self-assessment to do, unless she joins Michael in a joint filing in the US.
So making sure all the administration is up to date is going to be a critical first step to establish the advice to them. And Ed, from the investment perspective, looking at the different structures and assets in play, what would you be thinking from the planning perspective?
Yeah, just kind of echoing some of the comments that David's just made. Initially, the fact finding is really important. You can hear the tax filing obligations and the different tax positions are complex and constantly changing. And so we would really want to find out from the clients, but also David and his team, what that tax exposure is, because it makes such a difference to the net of tax returns for a family, not just Michael and Charlotte, but their kids as well. And what's their tax position? Are they US citizens as well? Because that will really govern how we go through the planning exercise with the family, how their investments will be taxed. But importantly, it doesn't remain fixed. We'll have to constantly review that, speak with David and his team, and really keep on top of that. In terms of the actual underlying accounts themselves, the brokerage accounts typically, given the fact that they're subject to both US and UK tax, would be taxed in both jurisdictions, irrespective of where they're held. The ISAs is an interesting one because in the UK, the ISA kind of product market is a UK thing, and often
very retail and commonly held, isn't it?
Exactly, and often the underlying securities themselves might be, which we'll come on to, kind of punitively taxed in one jurisdiction or another. And so in the UK, they're not taxed and don't have to be reported, but in the US, they're not recognised as a kind of tax-efficient wrapper and are taxed as though they're just a brokerage account. The pensions often are tax-deferred in both jurisdictions, and so once we've painted that picture, we can understand what investment should be populated in each of those different pots.
Thank you. And David, what are some of the additional US filing obligations that they need to be aware of on non-UK investments? FBAR, there's various things that people might have seen.
Yeah, that's right. It becomes a bit of a minefield with the US filing in particular, because we started off with just doing a personal tax return, but it's a spider's web that extends to all sorts of areas. So there is, you mentioned the FBAR, that's the foreign bank account report that annually has to be sent to the Treasury, separate from the tax return. There's also a form that goes in the tax return reporting all your foreign assets. There's some exceptions, but you're basically having to do your whole balance sheet every year. And then if you expand that even further to certain types of investments in PFICs, as we'll come on to, they've got their own separate set of reports to do. Foreign trusts as well, they've got their own separate set of reports. And if you're if your own sphere is in that of private business, you're going to have lots of additional compliance requirements and reporting forms to do every year.
And Ed, as a wealth manager investing some of these funds, what's your role in this, in helping people like David make sure the reporting's done right?
Yeah, I think reporting is one of the many pain points for US-UK connected families, because as we've heard from David, the obligations are extensive, particularly on the US side. And so typically we would want to make sure that our families that are US connected have both the proper US and UK format reporting. So on the US side, if they've got assets custodied in the US, typically a US institution would provide a 1099 as standard. They won't provide a UK tax report, and we'd have to kind of produce that for them. On the flip side, for the UK-based accounts, they won't get US format reporting, and so furnishing a US tax report in the format it would need to be calendar year, dollars, if it's custodied outside of the US, FBAR information, just to make that process easier, because it's just such a pain point for US connected families to keep up with the reporting obligation at various points throughout the year.
Thanks. And just turning then to the wealth management strategy, David, perhaps you could explain why US domiciled mutual funds are so toxic for UK residents and why UK funds also have issues attached to them. Can you explain a little bit more?
Yeah, I think I would say that's the trap for the unwary, because a lot of individuals will get advice in one jurisdiction or the other and be put into certain types of investments, but they actually, as you say, could be toxic in one jurisdiction or the other. So from the US side, you have what we're called passive foreign investment companies. So that could be actually any company, but it usually is collective fund investments. So anything that a UK advisor might put forward as even an offshore fund, it's going to be a problem from the US perspective, because the tax on that is trying to prevent deferral. Tax policy is being used to stop people investing in products offshore gaining a deferral. And then the flip side in the UK, similarly, there are rules which relate to offshore funds, so non-UK reporting funds, where any profits made on those or any excess income not distributed is taxed at an unfavourable rate. So you don't get capital gains, you get taxed at a higher rate. So both jurisdictions have equivalent systems which tax these at very unfavourable rates.
And Ed, how does that impact your role constructing portfolios? You've got these considerations on the UK side and the US. How do you minimise tax drag?
Yeah, it's a bit of a catch-22, isn't it, whereby Michael and Charlotte might have a brokerage account that has got both PFICs and non-reporting funds. I think the starting point always is to make sure that these portfolios are compliant from a US and UK perspective, avoiding PFICs, avoiding non-reporting funds. And then often I find that investing into a direct strategy, so into direct equities, fixed income, can be more efficient, because then you can be more granular in the tax optimization. It's typically more flexible if they want to move to a different country at some point in the future. But once all of that is established, you don't have to operate in silos. Whilst they might have all these different accounts that you've mentioned, so a brokerage account, ISAs, US pensions, UK pensions, looking at that all together and having a plan and populating the different asset classes across that is probably the most efficient way to look at it.
And David, in the picture here, we have Michael's $4.2 million of carried interest with a specific tax treatment. So perhaps you'd explain a little bit around how that type of asset is taxed.
Yeah, I think it's probably the most evolving area of tax law at the moment. It's particularly complex, and essentially in that world of private equity, those carried interests were being taxed at capital gains, so at very favourable rates, but particularly in the UK, where tax policies drifted towards this is being earned really from you working in the UK. So we want to tax it as employment income, not as profit, as capital gains on an investment. So it's really drifted in that direction. And HMRC have successfully changed policy over the years to the point now where they are almost successful in achieving that goal, where a lot of this carried interest will actually be taxed as income, not as a capital gain. The US has had less success in that area. I think they've required the holding periods of these investments in these, they're usually structured as partnerships underneath, to be held for longer to get capital gains, but there isn't yet an employment income equivalent like the UK has. So it's it's ever evolving, and tax policy constantly changing in this area. So I think it's watch this space as well.
Thank you. And Ed, on the currency front, how would Michael and Charlotte think about the reference currency, or how they invest linked to global currencies?
I think it's a common theme for US connected families that we're always discussing. I think typically you start with what their needs are and objectives and what their risk profile is, because that will drive the asset allocation amongst the family. And then that will then lead to jurisdiction plays in terms of, on the equity side, we often find that US connected families are overweight US, which makes sense. That's where a lot of opportunities are in the market.
I guess with dollar weakness at the moment, you know, it was a one-way bet, wasn't it, felt like? But that position is not there so much anymore, is it?
Exactly right. But it kind of then follows through to currency, because then if you're invested heavily into dollars, living in the UK, but if you've got an income requirement in your local country in pounds, that can significantly impact your spending ability, and particularly for a currency like the dollar and pound over the past couple of years has been quite volatile, and so that can have a material impact. In terms of some of the things you can do, particularly on the fixed income side, we would want to match currency with the investments. So for example, and this will depend on the allocation, but steering more towards pound UK qualifying corporate bonds and gilts to ensure that that pound income is matched to the way they're spending money. But often you still find that families are so connected to the US from a reporting perspective and like to see things in dollars. So you have to be pretty fluid, but kind of plan based on where they are and where they're spending.
Okay, thank you. And just turning to planning between the couple, so looking at spousal asset planning, David, I mean, how might they look at how they balance the assets between them, between Michael, obviously, who's the US person, and Charlotte, who's UK, and what's the implications for capital gains tax?
So that's a really interesting area. It does require a lot of thought and a lot of planning, because Ed's already touched on balancing and their currency exposure and so on. But both jurisdictions in principle permit transfers of assets between spouses without any tax issues. So in the right circumstances, it can be done quite tax efficiently. But there is certainly a distinction between the income tax and capital gains tax versus inheritance tax or estate and gift tax, depending on which jurisdiction you deal with. So I think we get into estate and gift tax a bit later in the inheritance tax side of things, but in principle, a transfer of an appreciated asset is subject to tax in the US and in the UK. But the US has this system of gift taxation. So if you're actually making a gift, so it's gratuitous, there's nothing being received in return, then it will override any income or capital gains tax. So it's subject to gift tax, not income and capital gains tax in the US. And between US spouses, there's no issue there. It's freely transferable. The UK similarly charges capital gains tax on transfer of appreciated assets, but again, if it's between spouses, it's done on what we call a no gain and no loss basis. So there's that ability to be able to transfer freely between spouses without tax currently, and then look at the longer term picture in terms of their strategic planning.
Thank you for that. And Ed, how does this affect your role in managing the money if you're rebalancing between spouses?
So we can always think about the different tax status of the couple that we're dealing with. And in this case, given the fact that David has confirmed that Charlotte isn't filing in the US and doesn't have a US tax exposure, that means that she can invest in funds that typically would be a PFIC, like they are for Michael. And really they deliver the same investment strategy, the underlying securities are the same, but they're just in a fund wrapper, and that comes with benefits. You know, you get UK capital gains tax roll up, there's certain VAT exemptions and other fee reductions as well. So these small benefits that really add up.
And it's reliefs, I suppose, as well, isn't it? That she could take advantage of reliefs, that if it's one part of the couple has all the assets and income.
Exactly.
Yeah.
So an example of that, like I mentioned in the past question, for the fixed income, so qualifying corporate bonds and UK government gilts, any capital gain on those is tax-free in the UK, but not in the US. So Michael could hold them, and often that makes sense because UK tax rates are higher, and if you can reduce that exposure, but even better if you can use her status, put them in her name, because then that capital gain is tax-free. And particularly the way that interest rates have moved over the past few years has meant that some of these securities you can purchase under par. And so a lot of the future return is built into a capital gain, albeit these are typically fixed income securities. So a really tax efficient way that you can deploy some of these fixed income securities across the family.
But there definitely are wins there to be had, aren't there? If the planning is properly done, there's opportunities there, aren't there? If under review you might find.
And on the income side as well, one of them, as David mentioned, a separate filing obligation in the UK. So even for other income generating assets, thinking about who holds those, particularly Charlotte, you know, she's got a business, what is her dividend income from that business? Income generating assets in her name generally could be more efficient.
Because she can control the timings as well of that dividend in a smaller range.
Exactly.
Okay, great. And David, Chelsea, the prime residence in Chelsea, that again is another trap, isn't it, for the unwary on the US-UK front?
That's right. It's interesting because it's obviously a UK-cited asset. So in theory, the UK has the right to tax that first under any agreements with the US. But it's a really complex area because if it's jointly held, which we assume to start off that it is between them, then they're both subject to tax in principle if they sell or transfer the residence. But I think it probably weighs more heavily on Michael. And I think this is where we're talking about balancing the ownership between the couple. Of course, we know there's primary residence relief in the UK. So when you sell your home, if you've lived in it all the time, there is no tax on the gain that you make on that sale. Well, the US only has quite a limited relief. It's $250,000. So I can imagine that a £6 million Chelsea home, if they've owned it for any length of time, there's going to be a lot more than $250,000 of appreciation there. And so everything has to go back to dollars. So you've got a currency exposure there too. And so Michael's really facing an issue with the US tax on that, even if it's exempt in the UK. So it's even more complex if you get into the divorce scenario, and we'll talk a little bit about that later. But what they might look at from a balancing perspective is whether the property might be owned by Charlotte instead of Michael, because there's no exposure to US tax there. But it's the other point that often gets missed is if there's a mortgage on the property and it's held in joint names, then there's a currency exposure there too, which people often are not aware of, that the repayment of that debt, because it's a foreign currency debt from a US perspective, you have to look at the exchange rate fluctuation between the point you took out the debt and the point you repaid it. And if you've profited on the exchange rate, you're taxed on that difference. So it's a sort of a little niggle in the background that might be there as well.
So people might underestimate the potential problems of just your house in Chelsea.
Exactly.
You're underestimating the issues there in the background.
Yeah, exactly.
Just looking at then estate planning, David, perhaps you could give us a sense of what are the considerations here around spousal exemptions between Michael as a US citizen and a non-US spouse. What are some of the considerations at play?
Yeah, I think I mentioned briefly earlier that there are, in the right circumstances, the ability to transfer between spouses with no tax impact. Now, in the UK, it tends to be a little bit more flexible because it's just a requirement to be married and have the same residence position. So if they've both lived here, Charlotte's obviously UK originally, but Michael's been here a good length of time. He's going to be what we call a long-term resident. And so they both have the same tax status. So they can transfer assets between them with no gain or loss on the transfer, and also to the other spouse on death as well. So for inheritance tax purposes, there's no tax charged. Now in the US, it's slightly different. If they're both US spouses, not an issue, same thing, there's no gains, no losses, free transferability, unlimited deduction for what goes to the other spouse. But the trap there, which is often not appreciated, is that a US spouse married to a non-US spouse, the amount that you can transfer is very restricted. Otherwise, you're subject to gift tax if you're happily married. So there's an annual threshold, it's about $190,000 now, I think. So you would be able to do a relatively large transfer every year to your non-US spouse. Otherwise, if you were trying to make a large transfer, such as, for example, the Chelsea home, if Michael was to give his share of £3 million, that is significantly in excess of that annual allowance. And so every US person, US citizen or domiciled individual, has an allowance of up to $15 million they can give away during their lifetime or when they die. So you could use that to make a large transfer to your spouse or indeed to anybody else. So there's that trap there that a US person might not be aware of, married to a non-US spouse. But it is common to look at that planning because, for example, with the home, it's exempt from UK tax. So if we can get that into Charlotte hands, there's no tax when it's sold. So that you would look at those sort of strategies. And it's similar again on death as well, because there are also added complications where you've got a non-US spouse in the picture.
And Ed, just looking at the UK IHT inheritance tax exposure. What would you be thinking about in terms of the investments and considerations there for their estate planning?
This goes back to the point of the fact-finding process, properly understanding the tax position of your client, not just income, capital gains tax, are they US, not US, but the UK really has been through so much change over the past couple of years for all taxes, and that has such an impact for how we think about the location of accounts, where they're based, the underlying securities in those accounts and certain situs restrictions. So that really comes down from an inheritance tax perspective. Are they long-term resident or not in the UK, which extends to Charlotte now, whereas previously it didn't. And so we'd want to think about all of that, but also be mindful of the fact that don't let it fully dictate their planning, because we have to consider their situation, their finances, their objectives. In terms of kind of planning opportunities to reduce that exposure, it's such a topical thing at the moment, and there are structuring opportunities which David and his team, alongside lawyers as well, would probably be best placed to advise on. So things like family investment companies or family limited partnerships, which are a slightly more efficient version from a US perspective. But even more basic than that, involving the kids, and we'd probably recommend that they have junior ISAs, again, if they're populated with US efficient investments given they're American, so direct securities, just moving more of that wealth into their name and getting them involved in that process. But probably being mindful of the fact the eldest is 18, and so now maybe old enough to have a brokerage account in their name, and there's an educational piece to that as well.
Is insurance a useful tool, both for straight protection, but also for investment structuring as well? How much do you see insurance coming into play on the estate planning side?
It gets asked about a lot, but it is a complete minefield given the US-UK complexity. The UK side, it is kind of domestic UK planning to reduce inheritance tax exposure, but and David will probably be better versed on this in terms of how that needs to be written on the US side to make sure it makes sense from both.
Okay, I mean, and just on that point, David, on the insurance front, if people are using insurance contracts for estate planning, what are some of the things they think about?
I think it's absolutely right that once you bring the US into the mix and you're looking at a more IHT-focused strategy, perhaps because the total wealth is below the thresholds in the US, so it's really exclusively the UK, you are looking at the income tax side as much as anything, and there are no readily available dual qualifying products. It's simple as that. There are very bespoke designed products that are out there on the market, but it's very difficult to get into that unless you're ultra high net worth, because they're very costly as well, often requiring lots of upfront funding and so on. And then as we've already talked about, there is the transfer tax in the US to keep in the background in mind perhaps you're thinking of doing a trust, put the insurance in, which then gets it out of your estate from an inheritance tax point of view, but you've got all those issues with the US and the fact that it might not be income tax compliant, number one, so you can't exit from it very easily. It could be full of PFICs as well, the same problem, but equally then it might not be estate tax effective and not an easy way to transfer to, unless sometimes you are using trust structures that can work, but it's very difficult, very complex area to deal with.
And also, David, on the estate planning side, we know that Michael's parents set up a Delaware family living trust 20 years ago and are now passed away. So we've got a historic kind of trust in the background. What does this mean for Michael as beneficiary living in the UK?
I think that is hitting the nail on the head. It's the UK, because this will have been structured very well in the US. From a US family perspective, we don't know if Michael's got lots of siblings who are still living in the US, but that's a very common scenario where mum and dad or even grandparents have set up this wonderful US estate plan where they're paying little or no US transfer taxes, but then all of a sudden there's one family member ends up in the UK, and you have to look at their relationship to the trust. Sometimes they're actually appointed executor and then they become trustee of the trust, and that drags the whole thing into the UK immediately, which is well, not necessarily a bad thing, but it needs a lot of work. But it's often the difficulties that UK beneficiary faces if there are siblings competing with competing needs, but they've got a UK tax issue to deal with and the siblings don't, where they've got a very efficient US structure. I think that's the most common scenario we see, where the UK family member is facing a lot more difficulties to plan around this and structure it in the right way so that they minimise their global tax burden.
So a central part of this scenario is the couple's marital strain and breakdown. As part of a regular meeting with them, if you were to hear of this and be involved in looking at their financial and tax affairs going forward, what are some of the things that you'd be thinking about initially based on what we know about the couple? I mean, Ed, from your perspective on the investment side, if they came in to say that they were looking at getting divorced, what would you be talking to them about?
I think initially the kind of idea that they've come to us jointly in a meeting and it's amicable and that's how it's come to us. Often it can come from various different points along the way from different advisors. But given the fact that they've come to us in a joint meeting, we have to deal with it in that way, but be mindful of conflicts of interest moving forwards as the kind of process goes on and the divorce proceeds, that will ultimately change. And I think at that point, it can be just myself or one of the other wealth managers in our business with them both jointly. But as time goes on, it would make more sense that they would have a separate representative each, to make sure they're properly heard and that they're being dealt with separately based on their own circumstances now as they're splitting. And the idea of a kind of divorce, the softer side of it, is a stressful life event, right? Emotionally, taking away the kind of technical complexity that we're discussing today. Often when clients come into us and they're going through a divorce, we have to manage their vulnerability in line with the FCA and from a compliance perspective. Do they need more support in the meetings? Do they need someone else with them? And so that's a real area that we need to assess properly.
And David, from your perspective, I mean, how do you approach scenarios like this, which will happen to the clients you advise?
Yeah, it is, as Ed's touched on, it's very sensitive, and as tax advisors, there is certain regulation that we have to follow, and the conflict of interest is one of the big ones. To whether we can continue to advise the couple jointly, now that can be possible with in the right circumstances, but equally making sure they are properly represented themselves, that they get independent advice and so on. So that it's a very difficult area to navigate, but if it's possible, we can do the work with them jointly, and that's very often preferable. But in other circumstances, if it becomes quite divisive or whatever else, they need to be kept separate, and very often we have to go our separate ways, and we in many cases we have to decline to represent either of them because we simply can't, because the conflicts are too great. But otherwise, we may be instructed by their lawyers separately to come in as part of a team to give some professional advice on the tax side, either jointly or separately. So there's many different ways, as Ed said, to approach it.
And assuming there is a path forward there to advise them, then what are some of the headline tax issues, or what are some of the questions you'd want to be digging into a bit further?
Yeah, I think there are a number that spring to mind, and it crosses borders, as you can imagine, and there are some conflicts between the US and the UK which just don't fit together, unfortunately, and you have to try and work around it. So it's trying to sort of tease out the sorts of things they're looking at from a settlement perspective in terms of ownership of assets first. Once you've got that in mind, you can start working around the tax principles. And so some of the bigger ones are, for example, when is this settlement happening, first of all? So how far down the road are they? Because in the UK, there's a very strict timing rule about when did you separate. And you have to look at, within 3 years, you have a window to transfer assets and sort your settlement out with no tax issues arising. But beyond that, you need a court order, otherwise you're going to be subject to tax on your transfers. So there's that timing issue. The US is less of a timing issue, but it's still quite sensitive in that respect, in terms of there is a sort of time frame given if you're able to do it without tax on the transfer. But I think the biggest issue we have to deal with is the fact that in the US, in a divorce, this is no longer a happily married scenario, so there's no gifts. So all that, we talked about gifts and estates already, that's gone out the window. We're dealing with a transfer here, potentially, of valuable assets. If it's moving away from the US ownership to foreign ownership, so if Michael's going to transfer anything to Charlotte, then the US will tax it. And so it's very crucial to get to the bottom of what their settlement looks like. We're assuming here that we're dealing with separate property, that we're in the UK, which is a separate property jurisdiction. They've come perhaps from New York, which is separate, so that's fine, it's all common law. It gets even more complex if you've got a community property jurisdiction involved or civil law of some kind. But really getting to the bottom of what they're looking to achieve in the settlement and the timing of that, I think, are the key things there. And there are certain assets which are hot buttons. The primary residence we've already talked about, that's the same issues if you were selling it as if you're transferring it. The pensions, we haven't really touched on that, but the ability to divide those pensions can be quite complex because maybe it's fine in one jurisdiction to divide up the UK pension, for example, but it doesn't work in the US, so you've got to try to make it work from a tax perspective as well, so it's tax efficient. And perhaps on a planning side, we don't know Michael's history particularly, but maybe he's got some old untaxed offshore income and gains that on the remittance basis. In a divorce context, it is sometimes possible to arrange the settlement through offshore accounts and manage transfers in a way that's not taxed from a UK perspective. So some of that money can come onshore eventually once they're divorced without any adverse tax issues. And then, of course, are they looking at a net settlement? So the tax is key to this, but also what are they looking at in future? It might be no tax now, but a lot of these assets have still got tax buried in them. And so do they understand that there might be no tax now, but later there will be? So yeah, it's looking at all those points, I think.
Wow, very complex. And Ed, from your perspective on the investment side, what are you thinking on this in this new scenario?
Yeah, just going off of kind of David's last point there, initially, whilst the divorce is kind of in the early stages and it's ongoing, the first point is the information gathering exercise that goes on to David and his team, but also a family lawyer as well, maybe two separate lawyers that they're both working with. They will want to collate an overview of everything. And typically where we're managing various different structures and accounts for a US-UK family, that can be a lot of information, and not just in one currency and tax terms, but looking at it both from a US and a UK perspective. So a key example, as David mentioned, when looking at unrealised gains, that can differ quite greatly in the US versus UK. So making sure they have that information to make an informed decision as part of the settlement process.
And how much do you look at, for example, if one party's getting a lump sum, how much that lump sum will yield if invested? How much are you looking into what the value, either whether it's a pension or a...
Yeah, that's a kind of process in itself, right? And typically where you split off into two separate advisors that are managing them individually, you'll go back to risk profiling exercise for them both individually and what are their objectives with that new pot or split of assets or potential split as the kind of settlement process is still being worked out. But going on to things like cash flow planning, which we may have done with the family already, we probably would have done with a tool that understands the various US and UK complexities and rules, but revisiting that now with a completely new share of assets and maybe not thinking about the US rules anymore because Charlotte doesn't have that exposure, only for the kids, which would probably factor in as well.
Do you also find that sometimes one spouse has less sort of financial education or comfort or knowledge on the sector and is kind of sheltered from looking at all of this in total, and all of a sudden they've got to make some pretty big calls on important decisions? I mean, what do you see from the financial side on that in this kind of scenario?
Yeah, absolutely. I think you can never assume from that perspective. Often you would get a feel of it, particularly in this case, when you're dealing with a joint couple, perhaps over many years, you get a feel for who's more involved or not. And so that will then paint a picture of perhaps their level of understanding from a financial perspective. But it's really important in that initial step of working out their approach to risk, their investment experience, and just their education of different asset types and how investments work, really breaking it down to a more granular level. Like we said, there's so much technical jargon, but stripping that away, what is an equity? What is a bond? And what are the different types of investment returns that they generate? And what does that mean for you over the long term? So really starting from that point and making sure they fully understand at a time when a divorce is taking up so much mental strain, and that's probably their focus point. So really making sure they understand is key.
Because also from the tax side, David, I mean, a party that's less involved financially might not have considered a lot of these tax points, but they all of a sudden get brought into focus, don't they?
Absolutely right, especially as you sort of mentioned, maybe the less financially educated spouse, if they are American, they are going to be inheriting all these issues. And so looking forwards, you may or may not have been involved in the divorce. You may be engaged after a divorce has happened, but understanding that background and then working with that client on their tax issues that arise out of a potential settlement. There's so many things which, if in this example, the couple, one spouse was, say, had not worked, didn't have the business, wasn't financially educated, but they are American, and they stand to inherit from their former spouse, who's UK. They'd have a UK pension, they have UK-based investments, UK assets. All of the US reporting they've never had to worry about suddenly comes into play. So you have to. It's an education process, like Ed said, which is, and it's emotional intelligence a little bit. You're working with this person who's a very vulnerable stage of their life, and trying to make sure that you do the best for them in terms of the overall global tax position.
And post-settlement, there might be new considerations. For example, if the UK spouse might not need to consider actually, or might have a different reference currency, they might need new estate plans. Once you've got the clean slate, then you're able to build for the future, isn't it, from there? And what are some of the things they might think about once they've gone through this difficult period?
Exactly right. So a lot of the issues we've already spoke about, but often, as David says, almost flipping them on their head, depending on who's got the assets in which accounts and what that picture now looks like. But for Charlotte, for example, previously as a happily married couple, we may have put more of the fixed income assets in her name as a family when looking at a kind of consolidated asset allocation. And now that could be that she's just left with more of those, even as part of the settlement, there's a joint split of a brokerage account perhaps. But we need to rejig that and rethink about what her asset allocation should be. That's probably the first step. Estate planning is kind of still there in the background and it's very relevant, and we would probably get onto that once the divorce has finalised and we've kind of got past the initial few years. But definitely revisiting it would be important, because their goals as a happily married couple probably have now completely changed from the softer side of it in terms of what do they want the kids to have or not have, and how do you approach that? And it will become very relevant as to how you then think about working with them individually, how they might gift assets, and how you do that.
So just looking at some of the practical lessons, I mean, whether this couple stays together or divorces, what are some of the big mistakes you see US-UK couples making, David, that they could learn from this scenario?
Yeah, I think it's, if nothing else they think about, it's making sure that they've looked at this holistically from both jurisdictions, no matter what stage they're at in the negotiations, or because to be sent down a road which very often happens, where there's been local planning and very good local advice in one jurisdiction, but the other hasn't been taken into account. So they could be locked into some of these PFICs or offshore funds, which are not taxed very favourably. So they're some of the basic things that can happen. But then they may also have been put into structures that look very good from one jurisdiction, or the obvious choice in that jurisdiction. For example, just having a holiday home in the US, you would always own that through an LLC if you were a domestic US person. But to put a UK person in that picture with an LLC owning real estate could be horrible from a tax perspective in the UK. So it's looking at making sure they don't fall into those traps. And we've touched on sort of family limited partnerships and family investment companies as an estate planning tool, and definitely they are very valuable tools, as well as trusts are still very much used in that area. But there's lots of things to just not get trapped into and to work with both jurisdictions together.
And Ed, I mean, what would your key sort of takeaway piece of advice be to US persons living in London, such as clients like this?
Yeah, I think one of them probably connects to David's last point, and on that topic of estate planning, not just talking about the various different structures that you can do moving forwards, but a review of your legal documentation, which is where a lawyer would be really important to make sure that you've got wills and the deeds, the trust deeds, are they all fit for purpose? What does that look like moving forwards? And I think that's on point of having a team around you of the various different professionals that really understand the US-UK complexity. So typically a wealth manager, a tax advisor like David and his team, a lawyer, and probably some other professionals around the sides as well for things like philanthropy and whatever it might be. But having that team around you that really get the US-UK complexity, I think is probably my best point of advice.
And looking down the track, what are some of the things coming in the next 12, 24 months that clients should be aware of in this US-UK space?
I think there's so much evolution in tax policy at the moment, both sides of the Atlantic, that we've had some sort of seismic shifts in the UK with the Labour government going down a certain road, especially in the area of what was non-domiciled individuals and changing that completely, changing the way that people are taxed. So we're still dealing with advising clients on what the implications of those changes are, but there's lots still to come. Lots of thoughts around how tax policy will change, particularly in the UK, around inheritance tax or pensions becoming subject to inheritance tax things. So there's lots of sort of tax policy factors. I think the exchange rates are always something to watch out for because we're having to, as we've pointed out, deal with, on the tax side, you've got to put everything in dollars in the US and sterling in the UK, and so that always plays into anybody's strategy in terms of where the trends are. And it can create unexpected surprises with gains and losses you didn't know you had. And I think the other thing is on the other side of the Atlantic is the direction of travel there. Especially, we only have to look at what was in the news this week with the Supreme Court in the US overturning the legality of the tariffs which President Trump put in place. But what we can see is certainly from the initial reactions there is that that's going to just continue. Because there are other means by which these tariffs can still operate, but in a slightly different way, but the complexities that international businesses face. So if, for example, Charlotte was looking to expand her business across the Atlantic, we'd have a huge issue to deal with there in terms of how to deal with all this international trade policy and the tax issues with that.
Thank you. And Ed, from your perspective, what's down the track that clients should keep an eye on?
Yeah, two things. I think the first of which David touched on slightly, which we didn't explore fully, but around the idea of Michael's non-domicile position historically and the transitional reliefs that are available to people that have been dealing with that over the past year or so, one of which is this temporary repatriation facility, which we are now nearly 1 year through the 3-year window till April 28 that you can benefit from that. So I think keeping an eye on that window and making sure you've properly assessed that your UK versus offshore cash flow planning needs are thought through, typically in the context of a divorce as well. If one spouse inherits mixed funds, typically that might limit their ability to spend in the UK. Secondly, I think just watching how UK tax policy evolves. We've already had changes in November to the investment tax rates in the UK for dividends and interest, and I think families, US-UK connected families, should be planning for that already. But I think on the agenda moving forwards would probably be inheritance tax reform of some type, and keeping an eye on that in terms of what that means for planning from a wealth management perspective.
Well, thank you so much for talking to me today, and I look forward to sharing this case study.
Thank you.